Greetings everyone. My name is Vardhan Gupta and my topic of presentation is geographical indication. Let's start with the introduction of geographical indication. Geographical indication is a type of intellectual property right that is used to protect products originating from a specific geographical location. A geographical indication is a sign or indication used on products that have a specific geographical origin and possesses qualities, reputation, or characteristics that are essentially attributable to that place of origin. Purpose The purpose of a geographical indication is to protect the product's reputation, quality, and authenticity, as well as to promote economic growth and development in the region where the product is produced. The use of geographical indication can also help to promote tourism in the region as consumers are often interested in the products that are unique to a specific geographical location. Rights provided under geographical indication are a geographical indication right enables those who have right to use the indication to prevent its use by a third party whose product does not conform the applicable standards. For example, in the jurisdiction in which the Darjeeling geographical indication is protected, producers of Darjeeling tea can exclude use of the term Darjeeling for tea not grown in their tea gardens or not produced according to the standards set out in the Code of Practice for the GI. However, a protected geographical indication does not enable the holder to prevent someone from making a product using the same techniques as those set out in the standards for that indication. Protection for a geographical indication is usually obtained by acquiring a right over that sign indication. These are the few examples of geographical indication tag. Some examples of the products that are protected by GI include Darjeeling tea, which was the first GI registered in India, and Gamosa of Assam, Tandoor Redgram of Telangana, Rakse Kapro apricot of Ladakh, Alibag white onion of Maharashtra, etc. These are some other examples of geographical indication tags. These are known for its unique characteristics and reputation, which are closely related to the place of origin. To be eligible for a GI protection, a product must have a specific geographical origin and possesses qualities, reputation, or characteristics that are essentially attributable to that place of origin. The product must also be produced, processed, or prepared within the geographical area. The application for GI protection is usually made by a group of producers or an association representing them. These are some cases of GI tag disputes which arose over the period of time. First is Darjeeling tea GI tag dispute. Darjeeling tea became the first GI tag product in India in 2004 and 5. The history of Darjeeling tea dates back to early 1830s. It was statutorily controlled by the government as the part of tea industry from 1933. Under various enactments culminating in the Tea Act 1953, the Tea Board vested with the authority to administer all stages of tea cultivation, processing, and sale through various orders. Darjeeling tea possesses a well-known flavor and quality, which has won the auspice and acknowledgement of discriminating consumers all over the world. There have been various disputes to the GI tag of Darjeeling tea. The Tea Board stated an action against ITC Limited on the basis of registered GIs. ITC Limited had a premier executive lounge named Darjeeling Lounge at its ITC Sunar Hotel since 2003. The board filed a civil suit in 2010 at Calcutta High Court, along with the prayers for an interim injunction seeking to restrain ITC Limited for using the trademark Darjeeling Lounge. They have contended that the use of Darjeeling by ITC led to the infringement of their registered GIs and certification trademarks. They also pleaded that the use of Darjeeling Lounge is an unfair competition act and has an effect of causing confusion amongst the various guests visiting Darjeeling Lawn, and that such guests would be falsely led to believe that there is some association with Darjeeling tea. That defendant pleaded that the Darjeeling primarily is the name of a place, and the tea is not the single most important aspect of Darjeeling Tea Board. Tea Board is therefore not entitled to claim singularity over the Darjeeling, considering that its monopoly ends at tea. Also, it was pleaded that the suit was barred by limitation since the use of Darjeeling launch commended, commenced over the period prior to the period of enactment of GI Act, and there was a delay in intimidating the suit. The judgment was that the suit filed by the Tea Board was dismissed, and the lawsuit was decided in the favor of ITC. The court found that the plaintiff's registered IGI and the certification trademark are restricted to tea, and the protection afforded by the same cannot be extended to the lawn services. So, our next case is the famous case of Kolhapuri Chappals. In the year 2019, the Controller of General of Patents, Designs and Trademarks, CGPDTM, granted geographical indication tag for Kolhapur. The ethnic leather chappals to Kolhapur, Sangli, Solapur, and Satara districts of Maharashtra and Belgaum, Dharwad, Balkot, and Bijpur districts of Karnataka. There was a joint bid for GI tag of Kolhapuri chappals by the Sant Rodias Leather Industries and Charmaka Development Corporation Limited of Maharashtra and the Dr. Babu Jagjeevan Ram Leather Industries Development Corporation of Karnataka in 2009, which fructified in 2018 into GI tag being granted in favor of the artisans of the two states. The reason for granting the GI for Kolhapuri chappals to two states and 8 districts within them was because of the large demand of Kolhapuris and the reduction of the supply of leather in Maharashtra. The second problem has been the change of taste among the youth of India and across the globe. The last reason was the rise in the competition. The most proverbial threat of Chinese imitation always looms large. So our next case is Tirupati Laddu, the savory from Andhra. The Tirumala Tirupati Devasthanam applied for registration of the Tirupati Laddu for GI tag under class 30. It received the GI tag in 2009. The Laddu derives its sanctity, reputation, and uniqueness from it being offered as Navedyam to the Lord. The Laddu is usually offered as prasadam to the devotees after they worship Lord Venkateshwara, the presiding deity at Sri Vari Temple in Tirupati, Andhra Pradesh. In 2009, a PIL was filed before the Madras High Court against the GI tag Tirupati Laddu by Mr. R.S. Praveen Raj, a resident of Trivandrum. He provided his suit on three contentions. The first one being the GI was granted to a single producer, and the second was there was a lack of distinctiveness, and third was a generic nature of the name. The petition was dismissed on the grounds that an alternative and effective form was available for adjudication of such dispute under the GI Acts. Such petitions could have been filed either before GI registry or the IPAB. The last case of is are the case of Navara rice Tamil Nadu versus Kerala. Navara rice is one of the many types of rice found in India and is a unique grain plant in Orzea group. It originated from Kerala and is well known for its medicinal properties. The granting of GI of this product in 2007 to Navara Rice Farmers Society has incensed other growers of the crop in Kerala and Tamil Nadu. However, it is stated that only farmers belonging to this society can sell their produce as Navara rice. Sridhar from Kerala-based NGO Thanal, who works with the farmers on sustainable agriculture, says nobody has evidence on the historical origins of Navara rice. Besides, you cannot grant GI on seeds because with migration, seeds also migrate and adapt to local ecology with genetic changes. He calls for more clarity in the GI laws. Now, we come to the part of registration. GI protection is typically granted through a registration system that recognizes the rights of producers and ensures that the consumers can trust the authenticity and quality of GI products. This system allows producers to control the use of their GI and prevent others from using the same name or labeling their products in a way that could cause confusion or mislead consumers. It also enables consumers to identify and choose authentic GI products that are associated with the specific regions and have certain level of quality and authenticity. In conclusion, overall, the protection of GI as a form of intellectual property plays an important role in promoting and preserving local cultures, traditions, and economies. By recognizing and protecting the unique qualities and characteristics of GI products, GIs can help to support sustainable development and promote the diversity and richness of global culture. At last, geographical indication is an important tool for protecting products that are unique to a specific geographical location, providing protection for the producers and consumers. It promotes economic growth, preserves cultural heritage, and ensures the authenticity and quality of the product. Thank you.